SJC-12056, Commonwealth v. Pierce A. Martin.
Ms. Naring, wait 1 second. All right, we are all ears. You may proceed.
Chief Justice, Honorable Justices, may it please the Court, I am Ilse Naring, and I represent the appellant defendant Pierce Martin. The issue before the Court today is whether the probation supervision fee, the victim services surcharge, and the victim witness fee should have been refunded to the defendant, Pierce Martin, when his guilty finding was vacated and a null pros entered. And this occurred because the underlying conviction was supported by a certificate of drug analysis signed by Annie Dukin. This case, it breaks down into two separate issues. First of all are the probation supervision fees, which were imposed under General Law, Chapter 276, Section 87A. And then there's a separate issue of the victim witness assessment, which was assessed under 258B, Section 8. With regard to the probation supervision fees under 276-87A, Mr. Martin paid a $65 a month probation supervision fee and a $5 victim services surcharge. This equaled $65 a month. It was assessed for a cycle of 12 months, and he paid $780. And he's asking this court to refund all this money to him.
So what are these things? What do we call them? I know we call them fees. Are they fines? What are they?
No, Your Honor, they are not fines. The law does not permit assessing monetary penalties. The probation supervision fee is designed, the $60 fee is designed to, if the purpose of probation is rehabilitation, then the purpose of 87A is to defray the cost of probation services. The $5 victim services surcharge is to defray the cost of services that are given to victims. So it's not a penalty for a crime, if that answers the question.
So if they are simply to defray the cost of services, why would they be refundable if the services were indeed provided?
Under traditional case law, a judgment and a sentence reversed is the same as if there had been no judgment or sentence. And this is the Murphy case from 1899.
Well, it wasn't reversed, it was null pros, ultimately.
The conviction was vacated and a null pros entered. And therefore, there was no finding whatsoever. So that if there was no finding, then the conviction was vacated, then there was no judgment and there was no sentence. And so there was a wiping out of that probationary period.
Though he actually served it.
I beg your pardon?
He actually served a probationary period, did he not?
Mr. Martin was placed on probation on October 9th in the year 2011. On January 4th of the year 2012, a probation warrant issued. That warrant remained outstanding until August 28th of the year 2012. He was reinstated into probation, and then his plea was withdrawn on October 31st of 2012.
Didn't he?
Oh, I beg your pardon.
No, thank you.
So for 7 months and 24 days, Mr. Martin was AWOL and received no services from the probation department.
Well, that
But
was his choice.
Yes, of course. Obviously, that was his choice. But the purpose of probation is rehabilitation, and the cost of 87A is to defray the cost of probation services. And where the defendant does not receive any services for rehabilitation because he's not there, then these costs, when he is absent,
Didn't he agree twice to probation? There was a guilty plea to 1-year probation that was agreed upon. And then when he absented himself, he was violated. He agreed to another year of probation to extend it so he wouldn't go to jail, essentially, correct?
on August 28th when he agreed to the reinstate, yes. And basically what is happening is that 87A fees are being assessed as penalties for a crime, in fact, rather than...
Wasn't being assessed to support the probation services that your client asked for?
Well, it was part of the sentence that was imposed by the court. And the purpose of probation is rehabilitation. And the services that were offered were deemed to be suitable to rehabilitate this particular defendant. And when he doesn't receive any services, and the court, and that he was required to pay for those 8 months.
Well, it was available to him. Isn't there a cost associated with making the service available should the defendant decide that he's going to show up on a given day? I mean, somebody has to be there to supervise him. That person has to be paid, right?
Yes, of course. And this is where the subset argument comes in, and that if in other jurisdictions that have handled this, they see it as an issue of quantum merit, where if a person has received services, then they can't disgorge them, and that the defendant would be unjustly enriched. And these were the 4 cases that I cited in my brief, in footnote 6 in the blue brief and footnote 14 in the gray brief. And those were the jurisdictions that dealt with this in Colorado, Idaho, Utah, and another state. So the defendants who had received services, but their pleas were reversed or vacated, weren't entitled to have their probation supervision fees returned. But if because they would have been unjustly enriched, but if we turn the situation around with Mr. Martin didn't receive any services for almost 8 months. It was 7 months and 24 days. But he was required to pay. And in that situation, it is the Commonwealth that is becoming unjustly enriched.
Are there public policy considerations that we ought to be taking into account, like not rewarding people who go AWOL?
He could have been incarcerated. I mean, that's a violation of probation.
Right.
Had to find him.
I beg your pardon?
They had to find him to do that.
Which might cost more money.
They always are found. And they did find him, and he came into court,
Right.
and he stipulated to his violation immediately on August 28th in the year 2012.
But there's nothing that requires I mean, your theory about why he should be repaid has to do with unjust enrichment, and that's the only theory?
Well, I would also...
Nothing statutory that permits this.
But then that becomes the point. It's becoming, if the purpose of 87A is to defray the cost of probation services, but then when a defendant is missing and then he comes back and he's required to pay for those months so not to be incarcerated for his violation, then it becomes a penalty for a crime, which is not permitted, in which it's 280, Section 6. It's also mentioned in the Zawatsky case. And also, too, it's becoming a money-making scheme. The defendant is being charged to support the general operating costs of the probation department for all probationers. And the probation supervision fee is assessed for his rehabilitation. And The conditions of his probation are determined by the court and the probation department to help him be rehabilitated.
But doesn't the doctrine of unjust enrichment have an equitable component? And are the equities really in your client's favor when he has turned his back on the probation services he would otherwise have been offered by virtually walking out the door?
My understanding is under quantum merit, a contract is created, but for some reason unenforceable.
Is there a
And
contract here? Where's the contract?
there are probation contracts.
Is that considered to be a contract in the same way that a contract to buy a car is a contract?
It's a different kind of contract because there's a conditional liberty interest at stake, but they are similar in that a party accepted services and compensation was expected, and that was the probation supervision fee, the under 276-87A. And then if under quantum merit, because if the contract was no longer valid, but the services had been accepted and it had been understood that money would be paid, then the party would have been unjustly enriched, the party who had accepted the services.
So as part of, if we take that argument, then are you suggesting that for the months that your client was actually around and subject to probation that he should pay?
Yes, that is one possible alternative here.
I thought your argument was more generally, that because this is a Dukin case and it was malprost, that he shouldn't have to pay anything. Isn't that your argument?
Of course, Mr. Martin would like all of his money back. And that is our position, that if the sentence was vacated, then, and as if it had never existed, then all the money should be returned, just as if prison sentences are wiped out. And that it would be a proper remedy to return Mr. Martin to the status quo before his due process rights had been violated by the egregious government misconduct.
Does that apply to all monies he paid, counsel service fee?
Probation,
Right, but he paid a counsel service fee, I assume,
the legal
correct?
counsel fee.
Right. Is he due that back?
I mean, for
That
his
really
his
wasn't an
initial
issue in this
plea of
case.
guilty.
Right.
It wasn't an issue in this case.
But I'm saying, if you're saying that he's entitled to be restored to have no monetary sanctions after the null process, right? So he gets all the money back he ever paid that was connection with this case?
The legal counsel fee. I haven't really researched it. That statute changed recently. Generally, when there's a dismissal or a not guilty, that isn't generally assessed, but I think after the budget crisis, it's a sort of a shall situation and it must be paid. I only know now with Mr. Martin that he didn't ask for that, and that's not why I'm here today. I don't even know if he did pay it.
If you're saying that he should only pay if he used the services, does that mean that any defendant who goes AWOL or otherwise doesn't use the probation services shouldn't have to pay the fee?
Basically, I am arguing that if no services are offered,
Well, they're offered, they just aren't accepted in that instance.
yes, but the purpose of probation is tailored to meet the needs of the particular probationer. And it's not a money-making operation for the probation department. It's the rehabilitation of this particular defendant before the court and the services that are deemed necessary to rehabilitate him.
Okay, thank you.
Good morning. May it please the Court, Suzanne O'Neill, Norfolk District Attorney's Office for the Commonwealth. This morning, I asked the Court to affirm the order of the District Court Judge denying the defendant's motion for return of his probation fees and assessment.
Let me ask you the same question I asked your sister. What are these fees? Is it anything materially different from a fine?
It's not a fine assessed.
We don't call it a fine, but I mean, I know it's not called a fine, but if there's a quaff or a conviction and you're put on probation, you've got to pay it. If there's a victim witness fee, you have to pay it.
Yes.
Does the fact that we call it a fee as opposed to a fine change its nature?
I think it does, because a fine can be assessed as a criminal penalty, and this is assessed for probation, but it can also be waived. Community service done in lieu of the fee.
But that
or-
relates to ability to pay, does not relate to
Correct.
anything else.
Well, it's a creature of statute. I'm not sure that I can answer your question.
Well,
I'd like to, but I see it as.
I guess my question is, if a person, if a corporation, for instance, is convicted at trial and assessed a fine of $10,000 and pays it,
Yes.
and then that conviction is vacated, they'd get back their fine.
I didn't find any case law on that, Your Honor, on a fine. There are cases in other jurisdictions where a statute is found unconstitutional, then a fine is returned. I did not find a case law on that in Massachusetts.
under, is it 278A, doesn't one of the provisions say that the assessment from any conviction or adjudication of delinquency, which is subsequently overturned on appeal, shall be refunded by the court?
258B, Section 8.
And that's the victim witness assessment fee. Yes, it says overturned on appeal. And I do point out that that's a distinction from a conviction vacated on a motion for new trial or a motion to withdraw guilty plea. And the reason I say that there's a distinction there is because the legislature very deliberately used a much broader term in Chapter 258D, Section 1 for wrongful conviction, where they say anyone who receives judicial relief. And I think that's a very important distinction, because they're not limiting it to overturn on appeal, but to a motion to vacate or a motion for new trial.
But that statute you're referencing was passed later, was passed after 258B, Section 8.
Correct, and I'd say that the legislature was aware of the language that they had used. They also used the same language for overturn on appeal in Chapter 280, Section 6B, which is the assessment, which is the drug assessment. So on certain drug convictions, there's an additional fee that can be assessed, or an additional assessment.
But why should we interpret, I mean, I know that they use that language, but I mean, so somebody basically has a wrongful conviction, they move for a new trial, the judge recognizes it to be a wrongful conviction and vacates it. That person does not get their money back, but the person who actually does not bring a motion for new trial and raises on appeal and it prevails, then that person gets the money back? Why would, either way, the conviction is vacated. Why would we interpret the statute to require it to go to an appellate court?
I understand. I understand that question. I think my answer is basically it's the legislative language. The legislature used very specific language, overturned on appeal, in two of the statutes, and they used judicial relief in another. And I also, in the Chapter 277, Section 73, which is for defendants held longer than 6 months if the case is ultimately an acquittal or not brought to trial, it's also very broad language and doesn't limit it to overturn on appeal. So from the Commonwealth's perspective, we're looking at the statutory language, and those are the very distinct terms used, and that's in terms of the victim witness assessment, which we see is different than the probation fees under 276-87A. And I think it was particularly clear for the defendant's case that if the purpose of probation is rehabilitation, then rewarding a defendant for not paying his probation fees and absenting himself from the services of probation.
Yeah, put aside the AWOL argument. I don't think that's worth your time, frankly.
Thank you, Your Honor.
I'm more interested in the issue of whether or not a fine would be refundable, and the question of whether a probation fee is, for all practical purposes, the equivalent of a fine.
Your Honor, a fine is, I would say, is assessed as a penalty, as a penological penalty under our criminal laws. It is a final, it is a final penalty that is not tied to a specific service or continuing condition that happens after sentence is imposed, whereas the probation fee, you have the finding of guilty or continuation without finding of guilty, and then the sentence is to either a period of incarceration that might be suspended, at which somebody receives probation services, or to straight probation. And then those fees are paid towards the cost of the probation services. The fine itself goes to the general fund and is not.
So does the probation supervision fee.
Well, I guess it's the distinction of it's not tied, the fine is not tied to this provision of services.
You can have a fine, I mean, a court could impose a fine on a defendant that the court is sentencing to prison.
Correct.
So they can go.
They can go either. But you,
I know, I'm saying you can go both, can't you?
correct, you can have imprisonment and a fine with,
You can't have imprisonment and a probation supervision fee.
at the same time, correct.
Although many states impose fees for those who go to jail or prison to reimburse the cost of going to jail or prison. This state does not, but I think many states do. Is the fact that this is intended for rehabilitation the difference here? Would it be a different, I mean, I'm trying to sort of sort out, because of course we have unsupervised probation and they pay $50.
But there's still services available, and it's not as though it's just a check and nothing else. There's still probation officers there. There's still check-in requirements. There's still, if someone doesn't comply with other terms of probation, the terms and conditions, then probation still becomes involved in that person's rehabilitation and services as they go forward. So it's not as though it's, administrative probation is just sending in a monthly check. There's more to it than that. And I'd submit that here, it's very important in probation cases. This one is illustrated. The Commonwealth asks for committed time, and the defendant requested probation. And while in many cases, the Commonwealth will agree to probation, if the defendant received committed time and the conviction is vacated, the time is the time, it's done.
Okay, but it wouldn't matter if the defendant here said, I don't want to be on probation. If the judge imposes it, he still has to pay the probation fee.
Correct, and he could also ask for a waiver. He could ask for community service. When he came in after being AWOL, he could have asked for a waiver. He could have asked for community service. He chose to ask for probation again.
Where on this continuum between a fine that's part of the sentence and a probation service fee does the victim witness fee fit in? What is that?
It's a legislative assessment. It's imposed in every case. It can be waived for hardship.
With written findings?
Yes.
But what is it? Going back to Chief Justice Gantz's initial question, what is it? So I understand your answer as to a fine, and I understand your answer as to the probation supervision fee, but what's the victim witness?
So at one point in time, the victim witness fee, it was deposited into a special account for that, and later, and I can't speak to the exact reasons why that section was repealed and it goes into the general fund, but to offset the cost for providing victim witness assistance under Chapter 258B.
Well, actually, the Zawatsky case actually says that it's, to quote, it is the assessment for the Victim and Witness Assistance Fund, or whatever, is not an imposition of a cost in that amount, and purpose of the charge are unconnected with the government's cost of conducting the prosecution against the defendant. Rather, the levy is directed to afford basic and fundamental rights in the criminal justice system to the victims and witnesses of crime. So it is serving a sort of separate purpose.
Yes.
But that purpose doesn't exist anymore because that's not a designated fee anymore because of the statutory change.
Well, the purpose still exists, the accounting is different.
Okay,
The purpose and the services provided never change. It's just the accounting of where it is deposited and where the check is written from. Those change, but
that's true.
and it's the same with the drug assessment, that at one point was deposited into its own account and now goes into the general fund.
So maybe I'm missing something, but I thought the point here was that the drug conviction was vacated because of Annie Dukin's involvement, meaning that there was egregious government misconduct involved, and that it was on that basis somehow that it was fair and equitable to refund all of these different fees. Is that not your understanding of the argument?
I think the defendant,
So that it wouldn't be available in other kinds of...
I think the rule that the defendant is asking for would make it applicable in any case.
Any no process.
And any no pros, which would, I think there's the Dukin cases, and I would note that this happened prior to Scott when the Commonwealth, it was October of 2012. It was uncontested at that time. I submit that if you look at the Charles case, there's a footnote that says there were 589 hearings took place within about a month and a half time period, and the Commonwealth acted swiftly to address cases. A cost-benefit analysis, a defendant with a possession of Class D, who had done a year probation, albeit not to our liking, but he had done it, that there was, the case was null prost, and therefore, in the Commonwealth's discretion, a null pros qui was entered. The other types of cases where that can happen, where it's not necessarily a reflection of the underlying merits of the case, but are the immigration cases, where you have the exercise of discretion many years after the fact by the Commonwealth to enter null pros qui in a case where a sentence has been served, and it doesn't necessarily serve a purpose to retry a case. But if we're looking at probation fees being refunded in any case where a defendant successfully vacates a plea, and then the Commonwealth has to make a decision whether to go forward, not because the facts of the case aren't there, but because of some other issue with the case, it seriously hampers the Commonwealth's discretionary function.
Does it matter that in this case, the defendant did not have to comply with both prongs of Scott? I mean, he didn't have to show that if he had known, it would have made a difference in his decision. I mean, he basically got a good deal out of the withdrawal. Scott did not apply. So does that matter in assessing his rights to refund of any money he might have paid?
I think the significance of that mostly is that the issue is never litigated, and you might have a case. I mean, one of the important things about the Dukin case is that it's a presumption of misconduct, and I don't mean to downplay by any means the Dukin situation, but it's a presumption. So in any given case, this case, the defendant didn't prove that there was misconduct in his case.
No. I'm accepting that. I'm talking about the second part of it where the defendant has to show that it would make a difference to him if he had known about the misconduct.
He got it vacated without having to go through
Exactly.
that second step.
Right. So does that matter in the analysis of whether or not he should get his money back?
I would say no, for the reason I think, and maybe because I'm analogizing it to the immigration cases where you also have that second prong doesn't go to, is a defendant, could they prove that they were not guilty? Would the Commonwealth not be able to prove their guilt in the case, but could a better deal have been obtained, or would they have done something different? And the second prong of the Scott analysis, just like in Clark analysis for immigration purposes, you're not looking at actual innocence or that the Commonwealth didn't have sufficient evidence of the case. You're just looking at what might have been done differently at that time. So I don't know if that answers your question, but I'd say I don't think, based on what the defendant is seeking, I don't think that analysis is determinative that would distinguish this from another type of case.
Okay, thank you.
Thank you very much. And I just finally asked Your Honor to affirm the lower court ruling.